Procedures when disciplining students with disabilities. Authority of school personnel. 34 CFR Section 300.530. Consistent with the requirements of the idea and used special education rules, as well as applicable use rules, each LEA shall establish, maintain, and implement policies and procedures for disciplining students with disabilities. Case-by-case determination. School personnel may consider any unique circumstances on a case-by-case basis when determining whether a change in placement, consistent with the requirements of this section, is appropriate for a student with a disability who violates a code of student conduct. General. School personnel may remove a student with a disability who violates a code of student conduct from his/her current placement to an appropriate interim alternative educational setting, another setting, or suspension, for not more than 10 consecutive school days, to the extent those alternatives are applied to students without disabilities, and for additional removals of not more than 10 consecutive school days in that same school year for separate incidents of misconduct, as long as those removals do not constitute a change of placement. After a student with a disability has been removed from his or her current placement for 10 school days in the same school year, during any subsequent days of removal the LEA must provide services to the extent required. Additional authority. For disciplinary changes in placement that would exceed 10 consecutive school days, if the behavior that gave rise to the violation of the school code is determined not to be a manifestation of the student's disability, school personnel may apply the relevant disciplinary procedures to students with disabilities in the same manner and for the same duration as the procedures would be applied to students without disabilities, except after the 10th day of removal that constitutes a change in placement. The LEA must provide services to the student. Services. A student with a disability who is removed from the student's current placement must 1. Continue to receive educational services so as to enable the student to continue to participate in the general education curriculum, although in another setting, and to progress toward meeting the goals set out in the student's IEP, and 2. Receive, as appropriate, a functional behavioral assessment, and behavioral intervention services and modifications that are designed to address the behavior violation so that it does not recur. The services may be provided in an interim alternative educational setting, IAES. And LEA is only required to provide services during periods of removal to a student with a disability who has been removed from his or her current placement for 10 school days or less in that school year, if it provides services to a student without disabilities is similarly removed. After a student with a disability has been removed from his/her current placement for 10 school days in the same school year, if the current removal is for not more than 10 consecutive school days and is not a change of placement, school personnel, in consultation with at least one of the student's teachers, determine the extent to which services are needed, if any, and the location in which services, if any, will be provided. If the removal is a change of placement, the student's IEP team determines appropriate services to be provided during the removal. Manifestation determination. 34 CFR 300.530. Within 10 school days of any decision to change the placement of a student with a disability because of a violation of the Code of Student Conduct, the LEA, the parent or adult student, and relevant members of the student's IEP team, as determined by the parent or adult student and the LEA, must review all relevant information in the student's file, including the student's IEP, any teacher observations, and any relevant information provided by the parents or adult students to determine 1. If the conduct in question was caused by, or had a direct and substantial relationship to, the student's disability, or 2. If the conduct in question was the direct result of the LEA's failure to implement the IEP. The conduct must be determined to be a manifestation of the student's disability if the LEA, the parent or adult student, and relevant members of the student's IEP team determine that the misconduct was caused by or had a direct and substantial relationship to the student's disability or was the direct result of the LEA's failure to implement the IEP. If the LEA, the parent or adult student, and relevant members of the student's IEP team determine that the misconduct was a direct result of the LEA's failure to implement the IEP, the LEA must take immediate steps to remedy those deficiencies. Determination that behavior was a manifestation of the student's disability. If the LEA, the parents or adult student, and relevant members of the IEP team make the determination that the conduct was a manifestation of the student's disability, the IEP team must either 1. Conduct a functional behavioral assessment, FBA, unless the LEA had conducted a functional behavioral assessment before the behavior that resulted in the change of placement occurred, and implement a behavioral intervention plan, BIP, for the student, or 2. If a behavioral intervention plan already has been developed, Review the behavioral intervention plan, and modify it, as necessary, to address the behavior, and 3. Unless the misconduct falls under the definition of special circumstances in Rule V.E.5 of the USPSAR, return the student to the placement from which the student was removed, unless the parent or adult student and the LE agree to a change of placement as part of the modification of the behavioral intervention plan. Special circumstances. School personnel may remove a student to an interim alternative educational setting for not more than 45 school days without regard to whether the behavior is determined to be a manifestation of the student's disability, if the student 1. Carries a weapon to or possesses a weapon at school, on school premises, or to or at a school function under the jurisdiction of an LE. 2. Knowingly possesses or uses illegal drugs, or sells or solicits the sale of a controlled substance, while at school, on school premises, or at a school function under the jurisdiction of an LE, or 3. Has inflicted serious bodily injury upon another person while at school, on school premises, or at a school function under the jurisdiction of an LE. Definitions. For purposes of this section, the following definitions apply. Controlled substance means a drug or other substance that cannot be distributed without a prescription, identified under Schedules 1, 2, 3, 4, or V in Section 202C of the Controlled Substances Act, 21 U.S.C. Section 812C. Illegal drug means a controlled substance but does not include a drug that is legally controlled, possessed, or used under the supervision of a licensed healthcare professional or one legally possessed or used under the Controlled Substances Act, 21 U.S.C. Section 812. Serious bodily injury means bodily injury that involves a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of a bodily member, organ, or mental faculty. 18 U.S. Section 1365. Serious bodily injury does not include a cut, abrasion, bruise, burn, disfigurement, physical pain, illness, or impairment of the function of a bodily member, organ or mental faculty that is temporary. 21 U.S.C. Section 1365. Weapon means a weapon, device, instrument, material, or substance, animate or inanimate, that is used for or is readily capable of causing death or serious bodily injury, except that such term does not include a pocket knife with a blade of less than 2.5 inches. 18 U.S.C. Section 930. Procedural safeguards notice. On the date on which the decision is made to make a removal that constitutes a change of placement of a student with a disability because of a violation of the Code of Student Conduct, the LE must notify the parents or adult student of that decision, and provide the parents or adult student the procedural safeguards notice. Change of placement because of disciplinary removals. 34 CFR Section 300.536. For purposes of removals of a student with a disability from the student's current educational placement, a change of placement occurs if 1. The removal is for more than 10 consecutive school days, or 2. The student has been subjected to a series of removals that constitute a pattern because a. The series of removals total more than 10 school days in a school year, b. The student's behavior is substantially similar to the student's behavior in previous incidents that resulted in the series of removals, and c. Of such additional factors as the length of each removal, the total amount of time the student has been removed, and the proximity of the removals to one another. The LE determines on a case-by-case basis whether a pattern of removals constitutes a change of placement. This determination is subject to review through due process and judicial proceedings. Determination of setting. 34 CFR Section 300.531. The student's IEP team determines the interim alternative educational setting, IAES. If the student's behavior is not a manifestation of the student's disability, the removal constitutes a change of placement, or the behavior falls under the special circumstance described in Rule V.E.5 of the USPSAR. Appeals by parent or LE. 34 CFR Section 300.532. General. The parents of a student with a disability or adult student who disagrees with any decision regarding placement or the manifestation determination, or in LE that believes that maintaining the current placement of the student is substantially likely to result in injury to the student or others, may appeal the decision by filing a due process hearing complaint. Authority of hearing officer. A due process hearing officer hears, and makes a determination regarding an appeal. In making the determination, the hearing officer may 1. Return the student with a disability to the placement from which the student was removed if the hearing officer determines that the removal was a violation of disciplinary procedures under the IDEA or used special education rules, or that the student's behavior was a manifestation of the student's disability, or 2. Order a change of placement of the student with a disability to an appropriate interim alternative educational setting, IAES, for not more than 45 school days if the hearing officer determines that maintaining the current placement of the student is substantially likely to result in injury to the student or to others. The above procedures may be repeated if the LEA believes that returning the student to the original placement is substantially likely to result in injury to the student or to others. Expedited due process hearing. Whenever a hearing is requested under disciplinary procedures, the parents or adult student or the LEA involved in the dispute must have an opportunity for an impartial due process hearing. The LEA is responsible for arranging the expedited due process hearing with the used State Director of Special Education, which must occur within 20 school days of the date the complaint requesting the hearing is filed. The hearing officer must make a determination within 10 school days after the hearing. Unless the parents or adult student and LEA agree in writing to waive the meeting or agree to use mediation. 1. A resolution meeting must occur within 7 calendar days of receiving notice of the due process complaint, and 2. The due process hearing may proceed unless the matter has been resolved to the satisfaction of both parties within 15 calendar days of the receipt of the due process complaint. The decisions on expedited due process hearings are appealable. Placement during appeals. 34 CFR Section 300.533. When an appeal through a due process complaint has been made by either the parent or adult student or the LEA, the student must remain in the interim alternative educational setting pending the decision of the hearing officer or until the expiration of the time period specified, whichever occurs first, unless the parents or adult student and the C or LEA agree otherwise. Protections for students not yet eligible for special education and related services. 34 CFR Section 300.534. General. A student who has not been determined to be eligible for special education and related services under the IDEA and who has engaged in behavior that violated a code of student conduct, may assert any of the protections provided for in this part if the LEA had knowledge that the student was a student with a disability before the behavior that precipitated the disciplinary action occurred. Basis of knowledge for disciplinary matters. And LEA must be deemed to have knowledge that a student is a student with a disability if before the behavior that precipitated the disciplinary action occurred. 1. The parents of the student or adult student expressed concern in writing to supervisory or administrative personnel of the appropriate LEA or a teacher of the student, that the student is in need of special education and related services. 2. The parents of the student or adult student requested an evaluation of the student, or 3. The teacher of the student, or other personnel of the LEA, expressed specific concerns about a pattern of behavior demonstrated by the student directly to the Director of Special Education of the LEA or to other supervisory personnel of the LEA. Exception. And LEA would not be deemed to have knowledge if 1. The parents of the student or adult student, a. has not allowed an evaluation of the student, b. has refused services under this part, or 2. The student has been evaluated and determined to not be a student with a disability under the IDEA. Conditions that apply if there is no basis of knowledge. If an LEA does not have knowledge that a student is a student with a disability prior to taking disciplinary measures against the student may be subjected to the disciplinary measures applied to students without disabilities who engaged in comparable behaviors. If a request is made for an evaluation of a student during the time period in which the student is subjected to disciplinary measures, the evaluation must be conducted in an expedited manner. Until the evaluation is completed, the student remains in the educational placement determined by school authorities, which can include suspension or expulsion without educational services. If the student is determined to be a student with a disability, taking into consideration information from the evaluation conducted by the LEA and information provided by the parents or adult student, the LEA must provide special education and related services. Referral to an action by law enforcement and judicial authorities. 34 CFR Section 300.535. Nothing in the IDEA prohibits an LEA from reporting a crime committed by a student with a disability to appropriate authorities or prevents state law enforcement and judicial authorities from exercising their responsibilities with regard to the application of federal and state law to crimes committed by a student with a disability. Transmittal of records. An LEA reporting a crime committed by a student with a disability must ensure that copies of the special education and disciplinary records of the student are transmitted for consideration investigation by the appropriate authorities to whom the LE reports the crime. And LE reporting a crime under this section may transmit copies of the student's special education and disciplinary records only to the extent that the transmission is permitted by the Family Educational Rights and Privacy Act. By the Family Educational Rights and Privacy Act. By the Family Educational